Welcome back, everyone. I'd like to introduce our keynote speaker for the midday portion of this conference. This is Ramogi Huma, the Executive Director of the National Collegiate College Players Association, which is a 501c3 that advocates on behalf of college athletes. Ramogi was himself a college athlete, a football player at UCLA, and he's been an advocate for the interests of workers in non-traditional situations across a number of these forums. So we're very happy to have him here at Utah. Thank you for giving the keynote.
Good afternoon. First, I'd like to thank the University of Utah for inviting me to give today's keynote address. It's a privilege to be able to discuss important issues concerning college athletes' rights and freedoms at such a pivotal time and with some of the nation's top antitrust experts. First, I want to make an important disclosure. I'm not an antitrust lawyer. I'm not an antitrust economist, so somewhat strange to be giving a keynote at an antitrust symposium. I find myself here today because over the course of serving as a college athletes' rights advocate for over 20 years, I've become keenly aware that the degree to which antitrust laws are enforced determines economic justice for college athletes. It's not much different than other Americans, actually. But most Americans don't know how much they benefit from antitrust laws. Think about what it would look like if every college in the nation, I know some of you were faculty here, went and decided to collude on a nationwide scale to limit the salaries of professors, deans, presidents, to no more than minimum wage in each state, maybe. Imagine other industries competitor nationwide agreeing to minimum wage compensation for grocery store workers, teachers, doctors, lawyers, any occupation really. And admittedly, it's ridiculous to even imagine. But this ridiculous scenario is the reality for college athletes. And it's always been surreal to listen to people earning fair market compensation in their occupations really discuss their opposition to college athlete compensation. And when some of them learn that antitrust laws prohibit colleges from agreeing to limit athlete compensation, they voice support in changing the laws to exclude college athletes from compensation and from antitrust protection. Unfortunately, no such law is currently in place. I serve as the Executive Director of the NCPA, the National College Players Association. And the NCPA is an advocacy group I founded while playing football at UCLA. And my inspiration to start the NCPA is directly tied to NCAA sports' long-standing antitrust violations. As a true freshman, I was backing up an All-American linebacker who had been on a radio show talking about how tough it was to get by as a full scholarship football player. This was during the middle of the season. We were undefeated, ranked number 12th in the nation, and he was on a radio show. On the radio show, my teammate explained that his monthly scholarship check had run out and he didn't have any food in his refrigerator. Someone who heard the radio show anonymously left groceries on his doorstep. Somehow the NCAA found out, and when they found out, they suspended my teammate. The NCAA suspended him because it deemed that the groceries were a benefit that my teammate only received because of his name and notoriety as being a college athlete. I learned about this during a team meeting after walking by the UCLA student store that was selling his jersey, fully capitalizing off of his name, image, and likeness, or NIL. Meanwhile, our head coach had a Cadillac sponsorship, drove that caddy to work every day. After that, my freshman year heading into summer workouts, it was made clear in a team meeting that we needed to attend summer workouts that were supposedly voluntary. To this day, it's widely known that summer workouts in D1 sports are supposed to be voluntary, but they're not. We used to call these workouts volandatory because if you didn't show up to these workouts, you'd be voluntarily sitting on the bench. The truth is that we wanted to attend these workouts to get better. The problem was that our school informed us that should we be injured during these workouts, the NCAA prohibited UCLA from paying for any of our medical expenses. We thought UCLA was lying to save a buck, but it was true. At this point, my frustration led me to establish the NCPA because I felt college athletes needed a voice and the means to bring forth justice. At the time, I really hadn't heard of antitrust laws, but now I recognize these injustices as a result of antitrust violations. The NCAA and its members function as an economic cartel, and in the issues that occurred during my freshman year, illegally limited college athlete NIL compensation and health benefits. That's why my teammate was suspended, and that's why we were all denied medical benefits during summer workouts. That's kind of the origin story of the NCPA and my role as a college athletes' rights advocate. And again, I'm not an antitrust lawyer, but as a college athlete advocate, it's impossible to fight for the fair treatment of college athletes without fighting for the enforcement of antitrust laws. Though the NCAA would say otherwise, college athletes deserve equal treatment under the law. It's a simple premise that no one should argue against. Things have changed since I played at UCLA. College athletes can now earn money for use of their NIL. Again, this means name, image, and likeness. However, antitrust laws played only an indirect role in these recently won freedoms. I was an advisor on the O'Bannon NCAA antitrust lawsuit. And in this lawsuit, former UCLA basketball player Ed O'Bannon sued the NCAA and EA Sports over the use of his NIL in the NCAA basketball video game. In the end, the district judge in Ninth Circuit correctly ruled that the NCAA violated antitrust laws prohibiting college athlete NIL compensation. However, the court's remedy allowed the NCAA to continue prohibiting college athlete NIL compensation. As a college athletes' rights advocate, it was a mixed bag. There was justice and there was injustice in this ruling. Prior to this ruling, we'd been unsuccessful in our advocacy to allow college athletes the option, or colleges, the option to provide full scholarships that covered the full cost of attendance. A dirty little secret in NCAA sports was that the NCAA cartel capped a so-called full scholarship below every college's cost of attendance, below the price tag of the school. It was deceptive to call scholarships full when price fixing them below the price tag of the school, AKA the cost of attendance. And this is one of the reasons why my teammate was suspended by the NCAA and couldn't afford the groceries in the first place. Prior to the O'Bannon case, I served as an advisor in the White versus NCAA antitrust lawsuit, which sought to end the NCAA's prohibition on allowing scholarships to cover the full cost of attendance, an illegal practice that deprived tens of thousands of college athletes of the means to fully pay for their education. Ultimately, I resigned as an advisor on the White case when the plaintiff's lawyers entered a preliminary settlement agreement with the NCAA in exchange for relatively small improvements and large legal fees, without the approval of the plaintiff, Jason White, and without my knowledge. But on the bright side, that case was the first case to certify Division I football and basketball players as a class in a class action lawsuit, which would be useful in subsequent cases. And the settlement also ended the NCAA's prohibition on colleges paying medical expenses during summer workouts or at any other time. One significant setback for college athletes in the O'Bannon ruling was that the Ninth Circuit's reversal of the district judge's remedy to include an option for colleges to pay athletes up to $5,000 above the cost of attendance in a deferred payment. The Ninth Circuit objected to the $5,000 because it was unrelated to education and that it could bring the end of amateurism and cause harm to consumer demand in doing so. The NCAA provided no evidence that paying college athletes this money would reduce consumer demand. In fact, 3 NCAA experts testified that $5,000 in deferred payment would not hurt consumer demand. Notably, Ninth Circuit Chief Justice Sidney Thomas dissented on the elimination of the $5,000 payment because the majority refused to consider evidence from both plaintiffs and defendants that the payment would not harm consumer demand. One major aspect of this action is that the $5,000 that the district court sought to allow was payment specifically for group licensing compensation, which is the licensing to use a group of athletes' name, image, and likeness in products like video games. The district court ruling stated, quote unquote, the injunction will also prohibit the NCAA from enforcing any rules to prevent its members and conferences from offering a deposit a limited share of licensing revenue in trust for the FBS football and Division I basketball players. In striking down the $5,000 payment, the Ninth Circuit stated, quote unquote, the district court clearly erred in finding a viable alternative to allow students to receive NIL cash payments untethered to their educational expenses. Again, the district court identified 2 pro-competitive purposes served by the NCAA's current rules, preserving the popularity of NCAA's product by promoting its current understanding of amateurism and integrating academics and athletics. So to be clear, we're talking about NIL compensation. The Ninth Circuit eliminated the $5,000 NIL licensing compensation because it could end amateurism and in turn hurt consumer demand, and because it has nothing to do with education. The Ninth Circuit went as far as saying that amateurism is integral to the college sports market and declaring it, quote unquote, self-evident fact that paying students for their NIL rights would violate their amateur status as college athletes. So it's important to point out that by the Ninth Circuit's definition of amateurism, amateurism today is officially dead. It officially died on July 1st, 2021, the date in which college athletes nationwide began receiving unlimited college athlete NIL compensation that is untethered to education. If it ever existed at all, amateurism is now extinct. It's also important to note that consumer demand and revenue are just fine in NCAA sports. And in terms of amateurism, even back in 2015, when this ruling was issued, it was clear that Division I college football and basketball were anything but amateur. Even then, multi-billion-dollar TV deals, paying multi-million-dollar coaching salaries and televising players with commercial logos all over their uniforms could not be characterized as amateur by any measure other than a cartel's excuse to illegally price fix the compensation of their labor. Today, we can point to evidence. For instance, Alabama quarterback Bryce Young has an estimated NIL value of $3.2 million. This value is not subject to any limit and is completely unrelated to education. And if his unlimited compensation that is unrelated to education hurts consumer demand, the rest of America did not get the memo. Last week, he was a starting quarterback for Alabama, where the game against Tennessee generated the highest college football TV ratings of the year. The Ninth Circuit should have wholeheartedly heeded the words of Walter Byers. Walter Byers was a former NCAA president of 37 years who built the NCAA into today's highly exploitative organization. In his tell-all book, which he expressed remorse for his actions, he stated, listen closely, he stated, amateurism is not a moral issue. It's an economic camouflage for monopoly practice. This is a confession. This is a confession by the architect of today's NCAA. The NCAA, conferences, and its member schools know that amateurism is merely an unjust defense for cartel price fixing that enriches schools, their administrators, and their coaches. In an interview that aired just days ago, Notre Dame athletic director Jack Swarbrick slammed so-called amateurism in NCAA sports. He said, I never understood it. How is amateurism a value? What's good about it? Each time college athletes get paid a little more due to a ruling, and in ways the NCAA testified would end amateurism, the NCAA doesn't declare the end of amateurism. It simply edits the definition to minimize athlete compensation in a way it thinks it won't be legally liable. Amateurism has never existed in NCAA sports, and college athletes should not be denied full protection under antitrust law to pretend that it does. In short, the Ninth Circuit denied college athletes full protection and relief under antitrust laws in the name of amateurism, a model that runs counter to our nation's capitalistic economic system, a model that runs counter to equal freedoms, a model that makes a mockery of federal antitrust laws, a model that imposes drastic economic exploitation upon college athletes. The Ninth Circuit's elimination of the $5,000 NIL payment on the basis of amateurism had serious consequences in the Austin versus NCAA antitrust lawsuit. The Austin lawsuit challenged the NCAA's prohibition to directly compensate college athletes above the cost of attendance. I served as an advisor in the Jenkins versus NCAA antitrust lawsuit, headed by renowned antitrust lawyer Jeff Kessler, which ultimately became the injunctive relief portion of the Austin versus NCAA lawsuit. In Austin, we won again. The courts ruled that the NCAA compensation limit violated federal antitrust law. However, instead of striking down all NCAA compensation limits as requested by plaintiffs, the district court only struck down NCAA compensation limits that are unrelated to education and no more than about $6,000 per year per athlete. And why is that? It's because the district court did not want to rule against the Ninth Circuit flawed precedent in O'Bannon stating that unlimited athlete compensation that is unrelated to education would destroy amateurism. Despite this major setback, This antitrust journey through the judicial system is now showing signs of reaching its full potential. The Alston case made it to the U.S. Supreme Court, which ruled 9-0 that once again the NCAA had violated antitrust law. Since the district judge had already narrowed the scope of the remedy to deal only with $6,000 in educational-related compensation, the Supreme Court decided not to decide on whether the NCAA's remaining compensation limits violate antitrust laws. So this was another ruling where justice prevailed and justice was denied. And the denial of justice was once again rooted in the Ninth Circuit's flawed decision in O'Bannon. However, the SCOTUS ruling in Alston was impactful in a number of ways. Among them, SCOTUS struck down the NCAA's claim that it was exempt from antitrust law based on dicta in a 1984 SCOTUS ruling in the antitrust lawsuit NCAA versus Board of Regents that said that college athletes should not be paid. SCOTUS also struck down the NCAA's argument that athlete compensation limits define amateurism and should be exempt from antitrust liability. So remaining compensation limits should be subject to the rule of reason. The SCOTUS ruling stated, quote unquote, a party cannot declare a restraint immune from scrutiny by relabeling it a product feature. Moreover, the district court found the NCAA had not even maintained a consistent definition of amateurism. It's true. This is a critical part of the ruling. When you think about it, if not for the Ninth Circuit's throwing out the $5,000 payment in O'Bannon on the basis of amateurism, the federal judge in Austin could have struck down all NCAA compensation restraints as Austin plaintiffs requested without worrying about running afoul of the flawed Ninth Circuit precedent. To be clear, here's a quote from the Ninth Circuit ruling in O'Bannon. They stated, quote unquote, the difference between offering student athletes educational related compensation and offering them cash sums untethered to education expenses is not minor, it's a quantum leap. Once that line is crossed, we see no basis for returning to a rule of amateurism and no defined stopping point. Well, dozens of states have since taken that quantum leap and ensured their college athletes can be paid unlimited amounts of NIL money unrelated to education. So the Ninth Circuit ruling prevented plaintiffs in Austin from winning a ruling striking down all remaining NCAA compensation limits. And this is a missed opportunity for justice for all college athletes, college football and basketball players at FBS schools especially. And the racial exploitation at the core of the NCAA compensation limits was not lost on U.S. Supreme Court Justice Brett Kavanaugh. In his concurring statement in Austin, he wrote, college presidents, athletic directors, coaches, conference commissioners, and NCAA executives take in 6- and 7-figure salaries. Colleges build lavish new facilities, but the student athletes who generate the revenues, many of whom are African American and from lower income backgrounds, end up with little or nothing. This is a fact. In 2020, I co-authored a study with Dr. Ellen Strowski, who's a professor of sport management at Ithaca College and Drexel University. The study is entitled, How the NCAA Empire Robs Predominantly Black Athletes of Billions in Generational Wealth. In our study, we applied NFL and NBA player revenue sharing percentages, approximately 50%, to college football and men's basketball revenues to calculate their fair market value. Our report found that during the 2018-2019 academic year, the fair market value of the average football and men's basketball player at an FBS college was $208,000 and $370,000 respectively. We found that over the course of 4 years, and after accounting for what these players received in the scholarship money, approximately $10 billion in generational wealth will have been transferred from college football and men's basketball players, again, the majority of whom are Black, to coaches and athletic administrators who are predominantly white. According to the NCAA's demographic data for NCAA Division I for 2018 and 2019, 79% of athletic directors are white, 84% of associate athletic directors are white, and 75% of senior women administrators and athletic departments are white. This wealth transfer has not only cost these athletes during the years when they're playing, it compromises what could be their long-term financial security. For example, if a college football or men's basketball player invested just $100,000 of what they should be compensated for into a retirement account at 6% interest over 40 years, their investment would accrue to over $1 million. Imagine a scenario where 100% of college football and basketball players have a clear path toward retirement, home ownership, and starting a small business by the time they're done with their college eligibility. In 2021, esteemed antitrust economists Hal Singer and Ted Tatos published a study called Antitrust Anachronism, the Interracial Wealth Transfer in Collegiate Athletics under the Consumer Welfare Standard. They also found that NCAA athlete compensation limits are responsible for a serious shift in wealth from predominantly Black athletes to white athletics personnel. In monetary terms, the flawed Ninth Circuit ruling, based on preserving amateurism, ultimately limited college football and basketball players to receive up to only $6,000 in education-related expenses when they're worth about $210,000 and $270,000 respectively. This is not justice. This is not freedom. Let's again consider the average American. How many would find it reasonable for a court to deny their market value based on what Jack Schwarbrook recognized as ridiculous and what the Supreme Court would rule to be an indefensible reason? I'd guess not one person in the country would be okay with that. I want to point out a few important points about the Austin case. And one is, just because plaintiffs' lawyers in Austin did not appeal the district court's decision to limit pay to $6,000 in education-related expenses doesn't mean that such a limit is safe from antitrust law liability. It's not. The Supreme Court simply did not rule on that issue because it wasn't challenged. In his concurring statement, Justice Kavanaugh wrote, "There are serious questions whether NCAA's remaining compensation rules can pass muster under ordinary rule of reason scrutiny." And also, just because plaintiffs in the Austin case did not challenge an athletic conference's ability to limit college athlete compensation doesn't mean the conference limits on athlete compensation are safe from antitrust liability. They are not. In fact, this point is underscored by a recent antitrust development in college sports. The Ivy League's congressional antitrust exemption expired on September 30th. The exemption allowed Ivy colleges to enter into agreements to prohibit athletic scholarships and merit-based scholarships. The expiration of this exemption is very positive. It's a positive development for Ivy League athletes. Decades ago, Ivy colleges were sued by the US DOJ for colluding to price fix financial aid. They eventually entered into an agreement to cease such activities. But in 1994, Harvard alum and then Senator Ted Kennedy successfully led Congress to approve an antitrust exemption that would allow Ivy schools to collude to prohibit athletic and merit-based scholarships without antitrust liability. The fact that Congress decided that it must issue an antitrust exemption to Ivy colleges to protect them from antitrust liability for their scholarship prohibition is proof that Congress, which has the sole power to issue an antitrust exemption, recognizes that these schools or any schools in a conference cannot limit athlete compensation without an antitrust exemption. Again, just because conference athlete compensation limits were not challenged in Austin doesn't mean that the conference limits on athlete compensation do not violate antitrust laws. And there are a few additional issues to focus on here. The first is that Ivy College's prohibition on athletic and merit-based scholarships, if they are still in effect, the prohibition is a violation of antitrust laws. The O'Bannon ruling struck down a previous NCAA rule prohibiting colleges from providing athletic scholarships that cover the cost of, the previous rule struck down the NCAA's rule of prohibiting colleges from paying scholarships to cover the full cost of attendance because it was an unnecessary restraint of trade. The Ivy League was exempt from this ruling until that antitrust exemption expired on September 30th. Under the O'Bannon ruling, the Ivy League cannot maintain its collusive and unnecessary ban on athletic scholarships without violating antitrust law. So far that I'm aware, the Ivy League and its colleges have not issued a statement about whether or not their collusive scholarship prohibition remains in place. And according to antitrust lawyer and former US DOJ Antitrust Deputy Assistant Attorney General Bob Lighton, if Ivy colleges maintain such prohibitions individually, even if the Ivy League announces an end to its scholarship prohibition, the colleges may still be liable for antitrust violations. Again, only Congress can grant antitrust exemptions. And if Congress wanted to permanently allow Ivy League colleges to collude and limit scholarships, it would have. And if Congress wanted to grant any athletic conferences an exemption to prohibit scholarships, it would have. but it didn't. Instead, Congress gave a small number of colleges special antitrust exemption for a limited time. And Congress has decided to allow that exemption to expire. It's a shame that Congress gave these schools an antitrust exemption in the first place. It's no doubt one of the reasons that the school's endowments have exploded. Last month, U.S. News reported that Harvard's endowment has ballooned to more than $50 billion. According to the Penn Political Review, Harvard's top 7 endowment managers earn over $58 million collectively. To put that in perspective, that's more than all of Washington State's total athletics revenue. And Washington State is a Power 5 school. The Ivy League scholarship prohibition has made enrolling and playing in college sports at these colleges cost prohibitive for many low and middle income homes, many of whom are Black. I was one of these athletes. I was fortunate enough to have been offered my first football scholarship to UCLA prior to my junior year in high school. This gave me a great option to weigh against any other offers. I had good grades in high school, and I remember receiving many letters from Ivy League colleges. By that time, I knew Ivy colleges didn't provide athletic scholarships. My older brother had been recruited by Columbia, and I remember sitting through a Columbia football recruiting presentation with him where they explained all of this. It was then that we knew that playing for an Ivy League college wasn't an option financially for my brother or myself. My brother ended up playing football on scholarship for the University of Idaho, and I had a football scholarship to UCLA. I remember at the time how terrible it felt tossing letters in the trash from Harvard and Yale and other Ivy League schools when these schools would have otherwise been among my top choices. There are many families like mine who shouldn't face the barriers to an elite education because of illegal activities. There are current Ivy League athletes who are seriously struggling under the Ivy League scholarship prohibition. Penn basketball player Lucas Monroe stated publicly, I live in one of the cheapest off-campus homes in the area. I almost got evicted because I couldn't pay rent. I don't know of any scholarship athletes that would get evicted because expenses like housing are paid for. Columbia women's track athlete Julia Jordahl Henry stated, many of us are desperate for financial relief. Every Ivy League athlete and recruit needs to know if our schools are going to begin offering athletic scholarships. We need to know if we can stop taking out student loans and working part-time. We deserve to have the same opportunity as our athletic peers to have our own financial burdens lifted. Students and athletes at Ivy colleges will either receive scholarships soon without a legal battle, or they'll receive it years from now through legal battles, and the Ivy League will be on the hook for treble damages. My hope is that these colleges will do the right thing, which is to publicly state that their collusive arrangement expired with their antitrust exemption and begin providing merit-based and athletic scholarships. As I mentioned previously, college athletes' NIL compensation freedoms did not come from the enforcement of antitrust laws. In the O'Bannon case, we won an increase in athletic scholarships, but the courts refused to strike down the NCAA's nationwide prohibition on athlete NIL compensation. Because the Ninth Circuit failed to properly remedy this, the state of California ended NIL compensation prohibitions harming California college athletes by passing an NIL law. Longtime antitrust economist and college sports reformer Andy Schwartz inspired California State Senator Nancy Skinner to introduce the bill. The NCPA co-sponsored the bill, and along with Andy, lobbied heavily for its passage. The bill, which is called the Fair Pay to Play Act, received unanimous bipartisan support and was ultimately signed into law. And it should be noted by the courts that the state of California enacted a bill to bring forth unlimited athlete compensation that is unrelated to education. And the state gave the law a name that makes clear amateurism does not and should not exist in California college sports, the Fair Pay to Play Act. Should also note that despite the objective anti-amateurism in California and among California colleges, one of the top 2 athletic conferences, the Big Ten, invited 2 California schools, UCLA and USC, to join. And in fact, all athletes in Big Ten colleges can now also earn unlimited amounts of NIL money untethered to education. UCLA and USC accepted the conference membership invitation, which gave the Big Ten the commercial value and leverage to negotiate a new TV deal that is expected to pay each Big Ten school an additional $25 to $45 million per year above and beyond the previous TV deal. This is evidence that amateurism is dead and the college sports industry is financially healthy with robust consumer demand. Now, prior to the passage of the Fair Pay to Play Act, the NCAA made public statements which amounted to threats of group boycott against the state of California. They said that California may not be able to participate in NCAA championships if the bill were to become law. Not long after, I was invited to give a speech at the US DOJ antitrust workshop by Macon Delrahim, who was then the chief of the DOJ antitrust division. I detailed in an array of likely NCAA antitrust violations, including the NCAA's threat of a group boycott against the state of California over the Fair Pay to Play Act. I called on the DOJ to investigate the NCAA in the same speech. Shortly afterwards, Delrahim publicly expressed his concerns over the group boycott threat and engaged in talks with the NCAA. As a result, the NCAA immediately stopped making threats against California and made no threats against other states that were considering similar NIL laws. After California passed the NIL law, the NCPA served as a primary supporter of NIL legislation in 12 other states, and I believe that it would have been more difficult to get NIL bills passed in some of these states if the NCAA continued with such illegal threats. As of today, there are over 25 states that have passed NIL laws to free their athletes from unjust NIL restrictions. While antitrust lawsuits didn't directly result in athlete NIL freedoms, the California bill was inspired by the O'Bannon lawsuit, and the Alston ruling made clear that the NCAA would be in violation if it attempted to restrain athletes' NIL freedoms. The Alston ruling forced the NCAA to scrap various NIL restraints it had been planning just days before the Alston ruling was announced. And importantly, the NCAA, conferences, and schools that fought so hard against NIL pay in the name of amateurism now publicly celebrate unlimited athlete NIL compensation that is unrelated to education. Amateurism is dead. If y'all didn't hear it before, okay, it's dead. And any notion from the courts that amateurism justifies remaining illegal limits on athlete compensation should die too. Antitrust law is an important avenue to eliminate remaining athlete compensation prohibitions, but it's not the only way. Affirming college athlete employee status is another way to gain athlete compensation. If college athletes are deemed employees, the minimum wage and overtime laws would require that colleges pay their athletes above and beyond current levels. And that pay would be in the form of compensation that is also unrelated to education. So not only would the athletes be in a position to receive fair compensation as employees, the Ninth Circuit ruling to eliminate the $5,000 payment because it was unrelated to education would die another death. Ironically enough, employee status could provide an avenue to legally limit college athlete compensation if college athletes negotiated and agreed to a collective bargaining agreement, or CBA. Compensation limits in a CBA do not violate antitrust laws, essentially because both sides would have had an opportunity to negotiate and agree to the arrangement. College athletes deemed employees would not be required to form a union or enter a CBA, but they'd have the option to do so. In short, if NCAA sports wants to limit compensation without breaking antitrust laws, it would ultimately have to agree to a fair compensation limit that incentivizes college athlete employees to go that route. This is the model in other pro sports, where we know that the players receive roughly 50% of total revenue in the form of compensation. Previously, and with a separate organization, I helped lead a campaign to establish employee status for Northwestern football players. To date, the only ruling on the books that weighed the merits of the case affirmed that Northwestern football players are employees. But on appeal to the full NLRB board, the board decided not to assert jurisdiction in college football. It did not rule that NCAA football players are not employees, however, which is an important distinction. And last year, NLRB General Counsel Jennifer Abruzzo issued a memo stating her position that Northwestern football players and similarly situated college athletes are employees. In response, the NCPA filed unfair labor practice charges against USC, UCLA, the Pac-12, and the NCAA as joint employers to give the NLRB an opportunity to affirm college athlete employee status. I expect that this issue will eventually be taken up by the Supreme Court, where several of the justices have signaled their willingness to view college athletes as employees. Also, as state NIL laws have demonstrated, legislation is a proven method to strike down remaining athlete compensation limits. Again, California outlawed athlete NIL compensation restraints, and it can strike down remaining athlete compensation limits. This is a top priority for the NCPA. Earlier this year, we again sponsored the California legislation on athlete pay. The bill would have ensured Division I athletes would receive 50% of the revenue that their respective team generates. Many college athletes already receive at least 50% of their team's revenue, but many do not. While the bill did not pass the Senate, it did pass two key committees, and we're working to sponsor a similar bill in the upcoming California legislative session. And if we're successful, we expect that the nation will follow suit, just like it did with NIL pay. Getting back to antitrust enforcement through the judicial system, I believe that due to a combination of the existence of the unlimited athlete NIL compensation that's unrelated to education and the SCOTUS ruling in Austin, this movement is finally set to knock down remaining college athlete compensation limits that prevent fair compensation. A current antitrust lawsuit, House versus NCAA, may ultimately unlock player revenue share of TV dollars. And with these developments in mind, the NCPA has filed an antitrust complaint with the US DOJ Antitrust Division. The US DOJ played a supportive role in Austin when the acting Solicitor General argued in favor of plaintiffs in front of the SCOTUS. The DOJ is intimately familiar with all of the details. The NCPA, along with Ted Tatos, provided information in support of bringing forth DOJ antitrust action against NCAA sports. Importantly, the NCPA has requested that the DOJ seek both civil and criminal charges over remaining college athlete compensation limits. I believe that only bringing civil charges will likely take 6 to 7 years to come to a conclusion in the courts like it did with O'Bannon and Alston. Whereas bringing criminal charges would likely bring a fair settlement, possibly within 6 to 7 months. All other antitrust cases in the NCAA allow those in charge of making legal decisions for the association free to gamble millions of the NCAA's money without any personal liability. In contrast, NCAA decision makers would likely want to avoid personal liability based on poor legal defenses. In discussing why NCAA sports has continued to hold on to the amateurism model, Notre Dame AD Jack Swarbrick said something very important. He stated, "We clung to an absurd model, amateurism. That made zero sense. Even after we were given that message by the courts, we still pursued it. Some of it was a lack of true engagement. The other was dubious legal advice." This underscores the need for the DOJ to engage NCAA sports with sound legal advice, cease and desist, or face individual criminal and civil prosecution. Every year, the US DOJ brings criminal antitrust charges against both corporations and individuals. Should NCAA sports and the titans of this industry be given special treatment above the individuals and corporations that the DOJ has prosecuted? According to SCOTUS, the NCAA is to be treated like any other business engaged in interstate commerce. It is not above the law. And I'd argue that there's no industry that so visibly, loudly, and deliberately flaunts its antitrust violations than the NCAA and its member conferences and institutions. Justice should apply equally to all who live in this country. There is no reason for the DOJ not to include criminal charges as it does every year to other antitrust violators. If the DOJ goes this route, every public or private statement, email, action made by individuals that uphold this collusive activity could come with criminal charges. I'd like to also take this opportunity to encourage every state to enforce its antitrust laws, all for the same reasons. State and federal antitrust enforcers ignoring the NCAA's remaining athlete compensation limits is like firefighters ignoring an inferno. So to conclude, NCAA sports is a chronic antitrust violator, a predatory economic cartel, and college athletes are the prey. Antitrust laws and antitrust enforcers exist for times such as these, and the time to act is now. Thank you.